Good evening, everyone, and welcome to our August Rights at Night. I am Lisa Morgan. I am a kindergarten teacher and the current president of the Georgia Association of Educators. While we welcome all public school employees, this event is only for GAE members and GAE staff. Therefore, if you are not a GAE member or part of GAE staff, please sign in by putting your name, personal email address, cell phone number, and school system in the chat to Lisa Morgan. We appreciate your interest in GAE. We hope you will join our organization today by visiting joingae.org. Everyone, please note that you must receive prior permission from the GAE Executive Committee or the GAE Executive Director before recording audio or video of this meeting. Social media posts concerning this meeting shall not contain information about the specific content of the meeting, although the sharing of general information about GAE and GAE events is encouraged. Please be courteous to other attendees and request their permission before posting photographs containing their images. If you have questions about social media posting of GAE events, please contact the GAE Executive Committee or the GAE Executive Director. Again, we are so glad you are here today. And at this time, I will introduce our presenter for this evening is our General Counsel of GAE, Mike McGonigal. Mike?
Thank you, Lisa. So I'm going to put up my screen sharing for my Code of Ethics PowerPoint. Start from the beginning. Oh, I've got to change it. There we go. Is it up, Lisa? I can see it.
Yeah, yes, it is, although we're still seeing your notes.
Well, is it my notes or the next slide?
It's the next slide in your notes. Go to that next one where it says swap presenter settings.
Okay.
And see if that gives us just the slideshow.
Oh, okay.
There we go.
Here we go. All right, great. So a quick refresher on GA Legal Services. We provide liability protection. Most of our cases don't fall under the liability protection. It's good to have that in the event that you are sued by a parent, for example, who has a special needs child. They may claim they're not receiving the services they're entitled to under federal law, for example. But those cases, the lawsuit cases, are only a small handful of the number of cases that we take in legal services every year. The vast majority of the cases that we take in are the employment and certification defense. And what's important to know there is that unlike our competitors, the NEA GA Legal Services Program does not have any predetermined cap on the amount of legal fees and costs that we expend in defense of member rights. So if we believe that the case is going to expand rights, or we believe the lower courts got it wrong, we have the ability and the resources to take cases all the way to, say, the Georgia Court of Appeals or the Georgia Supreme Court, and those costs can be, well in excess of $50,000, well beyond the cap that other organizations impose on their members. The other thing that makes us unique and better than other programs is that we file affirmative lawsuits against school districts. And you see there, I start the attorney fee meter running at $50,000. For example, we have filed a federal lawsuit on behalf of Cobb County member Katie Rinderly in the case of where she was terminated for reading My Shadow is Purple to her 5th grade class. There's a lot of media around the case. We are just getting started, and the legal fees and costs in that case will go over the $50,000, I'm sure. But just note that Ms. Rinderly and other members don't pay anything additional out of pocket in order to receive the benefit of the legal services. All they're required to do is maintain their membership with NEA and GAE. A brief note on the history of GAE. You can just see a brief timeline there. That, you know, dates are important, but they're kind of boring. There's very good literature or resources there that I put there, all written by an Emory professor who is now retired, Vanessa Siddle Walker. And you can look those up. The book about Horace Tate is about GA's first African-American executive director. It's about his experience in the Jim Crow South in the being administrator in all Black schools before the Brown versus Board of Education decision. The other book below, Hello Professor, is written about the integration of Gainesville City Schools with another GA member, Ulysses Bias. Dr. Bias led the highly successful Black high school in Gainesville, Georgia. And that tells the story of what his experience was like in the segregated city of Gainesville, and what integration meant, and how integration was implemented after Brown versus Board of Education. The paper at the top, real quick, The Organized Resistance and Black Educators' Quest for School Equality, also written by Professor Siddle Walker. She puts the founding date of the GT&EA, the Black Educators Association, as 1878. And it was, she says it was founded by a former slave, Richard R. Wright Sr., who graduated from Clark Atlanta University and was one of the brightest and most influential educators in the post-Reconstruction era. So if you're interested in that part of American history and GAE's history, I invite you to check out these resources. The PSC, I will just, what's always interested me about the PSC is that they're political appointees, the people that write the regulations governing teacher licensure and the code of ethics are actually appointed by the governor. So as we all know, as good GA members, voting's important and critical, but we need to elect governors that are friends, true friends of education. Because when there is a vacancy on the Professional Standards Commission, and if you're interested, you can give us your name through President Morgan, and we can advance your name to fill the vacancy on the Professional Standards Commission. Here is the composition of the PSC. A total of 18 members. This is prescribed by Georgia statute. And as you can see, half of the members of the commission are teachers from the classroom. So they bring their classroom experience to the state level and act as your judge and your jury when they are reviewing code of ethics cases. So the half are from the classroom, and you can see the other half are divided up in between public school administrators, higher education, 2 Board of Education members, as well as they wanted input from the private sector. And it can be a mom and pop company. I've seen the gamut all the way up to Coca-Cola and Georgia Power HR people have seats on the Professional Standards Commission. So 18 total members, half the classroom, half from the classroom, and the other half are divided up these other positions. And the idea is that from these people, this cross section of Georgia, they are to create a code of ethics, which is supposed to represent standards that are generally accepted by educators of the state. Generally accepted by educators of the state. 20 years ago may not be generally accepted today in 2024. And as we go along, I'll note some of the changes in the generally accepted standards, because it's interesting. We never know when the code of ethics will change. The current code of ethics is effective as of January 1st, 2024. I reviewed it, compared it to last year's code of ethics, and there were no substantive changes. They were literally things like adding commas and, I mean, just really, really grammatical changes, nothing substantive. The year before, they did put some substantive changes in there that we don't really have to go through, but just know that the current effective date of the Code of Ethics is January 1, 2024. One of the reasons we want to make sure when we make decisions, whether it's the Code of Ethics or local board policies, that you're looking at the most recent Board of Education policy that your local Board of Education should have on its website. You don't want to be making decisions that affect your career based on an outdated policy. So always check those dates. Definition of an educator is very straightforward. The only thing you really need to know is that when you sign an application for a certificate, you're swearing and attesting that everything that you state in the application is actually true and accurate. True and accurate. And once you submit it, you can't pull it back. It's going to go through the process, whether or not you've changed your mind or that sort of thing. Definition of a student. Also very, very straightforward. A couple of interesting points there that if you possess a teacher license from the Professional Standards Commission, it still follows you into a private school. So the definition of a student enrolled in a private school, if you're a teacher in a private school, you still have to follow the Code of Ethics in the private school. The other thing to point out is that for graduating students, their status as a student does not end magically when they walk across the stage and grab the diploma. They are still a student through August 31st. And this, you just need to keep that in mind because, friendships can develop, or you might want to celebrate with some refreshments with graduating seniors after they get their diploma, but just know their status as a student and your relationship to them as a student is that you are still the professional governed by the Code of Ethics. Even though they have grabbed their diploma and have graduated, that status continues on until August 31st. So now we get into the standards. There are 10 of them. All of them, for the most part, are very, very broadly phrased, very general language, which is the standard. And then after the standard often comes a laundry list of what is considered to be unethical conduct. So digging into standard 1, as you see, this basically says, we have to obey all federal, state, local laws, rules, and regulations, and local Board of Education policies. But where standard 1 really comes into play is that the commission has jurisdiction to investigate the commission or conviction of any felony or a misdemeanor involving moral turpitude. Now that term commission, trying to adjust this here, the commission is interpreted to be arrests. And a few years ago, I would not have been advising members to report arrests to the Professional Standards Commission. Excuse me there. Whoop. But these days, the commission has changed their views. And so nowadays, even if there's been an arrest, say over the weekend on a personal matter, then let's say involving a hostile argument with family members, and the police come and arrest the educator and the family member under Family Violence Act, has nothing to do with your status as delivering instruction in the classroom. However, it's better to report something like that on the front end, get it out of the way, rather than be accused later on of failing to report an arrest. I'm going to hold on. Sorry about that. Let's see. Sorry about that. Lisa, I'm still trying to get that share up again.
Yes, Mike, we're seeing, it's not to the share screen again. We're seeing your presentation with it's like in editing mode.
I don't know what happened here. Should I stop share and go back?
No, go up to the left and hit under the insert. There's a button from current slide. Go push that one.
Under current slide.
Under insert, where it's got file, then home, then insert. Under there, we've got from current slide.
Oh, file. Oh, I'm sorry.
Down just a little bit.
And go there.
There, yes.
Okay. Okay. Is that good?
It didn't change for us. Push it again. No, yeah, push it again. There it goes.
All right. Is that good?
Yeah, go back to the display settings and switch us back.
Sorry.
There.
Swap.
Yes.
There we go.
There we go.
All right. So I've covered that we need to report any kind of arrest to the Professional Standards Commission, excepting, minor traffic violations, things that involve, like I said, we've had a couple of situations this past couple of months where there's been very heated arguments with family members and they'd been arrested. We've reported it, of course, to the employer. Now, the employer, you also have to report arrests most times to your employer, report it to your principal, and to fulfill your reporting requirements with your employer, as well as the Professional Standards Commission. So what's a crime of moral turpitude? So you have to report misdemeanors involving moral turpitude to the Professional Standards Commission. And that includes misdemeanor theft by taking. And I just want to mention a case where an educator was walking out of a Walmart in Orlando, Florida. She paid for all of her purchases, except she was holding a $2.37 Coca-Cola. And the loss prevention followed her out of the store and called local law enforcement. And she was arrested, even though she said she would pay for the Coke, all the rest of it. The local law enforcement decided to arrest her for $2.37 Coca-Cola. She spent 3 nights in jail because this was a Friday. She hired a lawyer. She bonded out. She paid fees. And the total amount between the arrest, 3 nights in jail, fees, fines, and court costs, $2,700 in attorney's fees. When it came time to recommend a sanction for this member, they claimed she had falsified, that she didn't disclose this $2.37 plea of guilty on her application. So they said she falsified a record, and they wanted to suspend her license for 20 days, which would have amount to $6,828.60 for a 20-day suspension over a $2.37 Coca-Cola, which she failed to disclose on her application. And my point is that the Professional Standards Commission does not contextualize these cases at all and look at the monetary amount and so on and so forth. And she was a Black woman in Orlando, and the law enforcement were white sheriff's deputies, and she wanted to pay for the coke. They didn't let her. All those factors don't go into the professional standards analysis of whether or not they should recommend a sanction. So it's very serious stuff. But thankfully she has us as her legal representatives. So these are the crimes that you do not have to report to the Professional Standards Commission, even if you have a conviction. Driving under the influence is one. That's a very common occurrence in the educational community. When I began employment here at GAE, my workload of certification cases, I'd say half of them were DUI cases. I argued for years that a DUI has no impact on the educator's ability to deliver instruction in the classroom, and it really didn't. But the PSC would end up recommending sanctions, even if they were sanctions such as a reprimand, which does not interfere with the educator's ability to teach, because a reprimand is not a suspension. If you're suspended, you don't technically even have a license for the period of suspension, but a reprimand allows the educator to continue teaching, unless they had more than one offense on their record, then they might suspend them. But I don't remember the year they decided to not investigate or not require reports of convictions of DUI to the PSC. And I believe that came in the era when standardized mandated testing was brand new in Georgia. And they were kind of looking at a workload issue, because the number of standardized testing violation cases was just spiked. And they finally convinced themselves, I guess, that DUI was not as serious an offense because it didn't have an impact on the classroom. And so they decided to pass a rule that you didn't have to report a DUI. Similarly, you can see assault and battery doesn't have to be reported, things like that. Now, I don't know why child abandonment is on that list. That makes no sense. That clearly would be a crime of moral turpitude. But for some reason, the Georgia criminal law has developed over the couple centuries that they've been litigating these cases. For some reason, child abandonment is not on the list of crimes of moral turpitude. So I mean, there it is. Go figure. Are there any questions in the chat, Lisa, or anything like that so far?
Not yet.
Okay. Well, we're here to ask questions, so don't forget to put them in the chat and Lisa will ask them. So we're on standard 2, and that's your basic boundary rule. You're to maintain a professional relationship both inside and outside of the classroom. You might run across a parent and a student at the gas station or at the Piggly Wiggly or the Kroger, what have you, on your own free time, on a weekend. You're still wearing your educator hat, even in those non-classroom settings. And these are all common sense boundary issues that you all have a lot of training on, and everybody does a pretty good job in that. This is the list that I was referring to. After the standard, there's a list of unethical conduct. And under standard 2, you can see it's stating the pretty obvious bad stuff, so to speak, child abuse or physical and verbal abuse, engaging in harassment, misconduct, all of those things that pretty much, you don't really see a whole lot of cases under standard 2 like this. But it's just pretty much common sense boundary rules. Your mandated reporters, I just wanted to touch upon this on the seriousness of that. Your reporting requirement is you have to report child abuse or suspected neglect within 24 hours. And the courts have strictly construed that. And so what that means is it's a classic case where it's a Friday afternoon and the student comes up to you and it's late in the day, classes may have been dismissed. The student didn't want anybody around because he or she was going to share with you some private information that, say, a family member was inappropriately touching them, and you attempt to call administration. Administration may have already gone home. The educator at that point can do, I think, one of two things called the central office to see if anybody at the central office they can receive a report of suspected child abuse. But failing that, the educator has a duty to call local law enforcement. If you've exhausted your reporting, fulfilling your reporting requirements at the school level or central office level, and it's on a Friday, don't ever think that, oh, I can wait until Monday to report this report that was made to me by this child of suspected child abuse. They have been touched inappropriately. Can't do that. And there are those cases where the educator did wait until a Monday and there was a repeat occurrence of the inappropriate touching that occurred over the weekend that could have been prevented had they reported it. And even if there was not a repeated occurrence of the inappropriate touching over the weekend, the failure to report it within 24 hours and waiting until Monday can end your career. It can end your job and end your career. So you probably had all the in-depth training on mandated child abuse reporting, but I wanted to emphasize that. The other thing I would just emphasize is your duty is to report, not to investigate. And I've seen a few situations where family members work at the school where the child is attending the school, and the student would come to you and make these a statement, divulge a confidence they were touched inappropriately, but the grandma or the auntie works at the school, and rather than report that, you go to the family member and ask them about the student, what was reported. And that's a big mistake too, because the family member may know about it, but they're so embarrassed and humiliated by it, and they don't want to expose the family secret that they might want to sweep it under the rug. And you think, oh, okay, I'll believe the grandma or the auntie, and I won't report this suspected child abuse, inappropriate touching to the administration. Your duty is to report, not to investigate.
Okay, Mike,
Yeah.
The question is, and if the district has a policy that we are to report to an administrator in the school or a district resource officer, how does that impact the PSC policy?
Well, how does that impact the PSC policy? I guess if what I'm hearing is if you fail to report, you will be referred to the PSC for allegedly violating the code of ethics.
Okay, but if I guess the question, I'll reword the question.
Okay.
If my district has a policy that says if I suspect child abuse, district policy tells me to report to my administrator or
Right.
the school resource officer or the counselor.
Right.
if I follow the district policy and
Right,
report to that person, am
right.
I then in compliance with the PSC policy for
Yeah,
reporting?
yeah,
Okay,
I would argue yes. Yeah, I don't see a problem with that. Yeah,
okay.
okay. Um, yeah, and that's following the statute. I don't have the statute up in front of me, but I can kind of visualize it and see that you have to follow the local school district reporting procedures at the building level. That's what the statute says, within 24 hours. And you can't investigate on your own behalf. So because we're dealing with standard 2 conduct with students, I put in I think a little bit on social media, just as a reminder that think before you post something to social media, whether it's Twitter, Instagram, TikTok is a big one, and of course Facebook, because what you post may end up not only on the front page of the local newspaper, but you can be discharged from your job and potentially run afoul of the code of ethics. But we have to look at these cases on a face-by-face basis. So your strongest protections, however, under the First Amendment that protects free speech of public employees is really limited. Its protection is greatest when you're speaking as a private citizen on matters of public concern. Now, when you're on the clock working as a public school educator, teacher, parapro, secretary, school bus driver, you name it, chances are you're not really a private citizen, are you? So, and even if you're speaking on a matter of public concern, you're speaking, as a school employee. So, we don't find a whole lot of cases at all when you are speaking on school time about important issues, say about class size, or waiving the duty-free lunch law, or waiving fair dismissal, or waiving the state salary schedule. We could go talk about waivers all night. So if you go to appear before the local Board of Education, you can get on the list and identify yourself as a taxpayer, a resident. I'm a voter, of the county in which I'm speaking. I'm a parent. I'm a grandmother, aunt, uncle. You need it. You want to layer on your statuses in addition to being an employee. But you want to layer on all these additional statuses to give you a buffer and protection and assert that you're speaking as a private citizen, not as an employee. And then, of course, speaking on a matter of public concern. You don't want to speak as a taxpayer about how I got a bad evaluation in my job. That wouldn't work. You would speak as a tax-paying private citizen on, again, waiving class size. It's a district-wide issue that all taxpayers of the county or city school system would want to know about. And there's data to support the idea that smaller class sizes leads to higher student achievement, as opposed to waivers, of which there is no data supporting this idea that if you waive education laws, student achievement will increase. That's the bargain that they make with these waivers, but it's all it's a flim flam. It's a part of a larger design to privatize public education, to make the idea that choice and vouchers are more attractive than public education, by making public education like overcrowding the classrooms, for example, does not lead to higher student achievement, which is why they allow waivers. But anything that your local school board waives can be unwaived through political pressure, which again, we need to vote for local school board members who are going to support us support public education, and support better working conditions, because that's what the kids deserve. That's what our students deserve. The waiver concept does not lead to higher student achievement. There's no data to support that. Well, this is just a quick synopsis of a case involving a teacher in Tift County who was on her own time posting about a holiday parade that involves some Black Lives Matters marchers. And she was posting about this on her own time on Facebook. And, you know, Black Lives Matter comments about them is a matter of public concern. And this individual, not a GA member, I'd add, was saying things, however, that were very incendiary, such as, you know, pull up your pants and quit impregnating everybody, and she's sorry to be paying for these thugs. Well, all of that went out on her Facebook page. And even though she was speaking as a private citizen, speaking on a matter of public concern, as controversial as it was, it caused a disruption in her classroom and at school. Because if you can imagine, if you're a African-American student or African-American parent there in Tift County reading about those comments that Ms. Tucker posted about Black Lives Matter, you wouldn't want to be in her classroom anymore. So it caused a disruption, in the Georgia Court of Appeals, as you see, there's the case citation, dismissed her First Amendment lawsuit because it caused a disruption in the classroom. Standard 3, again, there's very broadly phrased, refrain from using alcohol or illegal or unauthorized drugs in a course of professional practice. The interesting thing to me is that you are to refrain from using alcohol even if students aren't present. And which is kind of interesting. And I'll tell you, the way that came about was years ago in the summertime, and it's very hot, and we're going through another hot spell right now. But teachers would come to school with no air conditioning, setting up their classrooms, working up a sweat and working up a thirst, and somebody would bring a cooler of refreshments to, you know, whether they were hard cider or beer, whatever it is, and they would start, you know, socializing and drinking alcohol. No students around. It didn't seem like there was any harm until somebody got the bright idea, after they've had a few of these liquid refreshments, to go into the gymnasium and play a game that I'd never heard of before called strip basketball. And the strip basketball story became legendary, and it was put into the media. And of course, the Professional Standards Commission heard about this game of strip basketball being played at school, even without any students around. They felt that that was very unprofessional, obviously representation of the school and the community. So they added the words without students being involved. So that's the history of that. So here's a hypothetical on Standard 3 as well. Two educators acting as parent chaperones, so they're in their private capacity as parents, attended a play with a Fox High School drama class at the Fox Theater. And during the meal with students at a nearby restaurant, the educators had 2 glasses of wine with their meals. Now, complaint goes to the PSC, filed against these 2 parent chaperones. They're also educators. The parents are going to argue, well, I was not there as a teacher. I'm there as a chaperone. You know, here's the sheet that I signed up. It says I'm not an employee. It says I'm a parent chaperone. The PSC will hear none of that. The PSC is going to say, we don't care about that. You're still an educator in our eyes. And drinking alcohol with students present violates the code of ethics. Now, in this scenario, educators are having a good time at a private party at a local restaurant. Faculty members are there, no students were present. That's not a violation of the code of ethics. But drinking, going home and driving while intoxicated, getting into an accident, or those may not be a violation of the code of ethics, but it's something that you don't want to do. So standard 4, again, is broadly phrased: be honest, exemplify honesty and integrity in the course of professional practice. What could be more simple than that? And here's the list of what is considered to be unethical includes falsifying, misrepresenting, or omitting. And then they go on to say, we touched on criminal history, employment history. A common question on employment applications, for example, have you ever been non-renewed, for example? You have to be truthful and honest if you were, and attach an explanation. But you don't want to try and fudge around the perimeter and try and get into a linguistic or rhetorical ploy here. Information submitted to the government, that could be grants, for example, or it could be your taxes. I've seen a few cases over the year where educators have been gone through the adjudication of falsifying tax returns, and that violates the code of ethics as well. Number 4 is the one that I probably see a little bit more of. Reasons for leaves or absences, and the only takeaway there is that if you're sick, please be sick, because we're in the day, everybody has a camera phone, and you don't want to call in sick like a coach did years ago, call in sick, and he was next on national television at the Final Four being played here in Atlanta. And everybody on national TV saw this coach at the game, enjoying himself, having a good time, which is great. But the problem is, the people in his home school district knew that he had called in sick. So we're often running to the races for falsifying reasons for being out. So if you're sick, be sick. So some of the cases, and you can read them, and I'd say that forging a parent's signature or a colleague's signature on the IEP or SST records, you can have the person come in and testify that I talked with Lisa Morgan in the hallway, and she was fine with modifying the IEP, and then she had to run off to class. So I went and signed her name on the IEP, modifying an IEP. At the hearing or the trial, you can have Lisa come in and provide that testimony. It's not going to go anywhere, because the deed was committed in fact that I signed somebody else's signature to a government document. We don't even really want to go there like we did in the Atlanta so-called cheating scandal, where educators were prosecuted and are serving time in jail or community service. I can't keep up with they were all sentenced, found guilty for falsifying government records. I haven't seen a case of falsifying an IEP or an SST record being prosecuted. Theoretically, it could be. But just, may seem common sense, but don't sign somebody else's name to a record, even if you have their express permission. That's not a defense that's going to be very strong or persuasive. Public funds and property, where we go to work every day is a public school funded by taxpayer money. The computers we use, pretty much everything there is public publicly funded. This particular standard, though, really gets to public funds. So if you're taking up money for a club, or you're raising money for the basketball team or the cheer team, make very, very sure that you're keeping very accurate records. Make sure that you have approval from administration to do this. We get calls, cases every now and then where educators kind of let their guard down a little bit and start using GoFundMe or some other fundraising websites to raise money for a good cause, and everything's all legitimate. But administration has to approve that. Most schools and school districts have policies saying that before you can do that, you need our permission. The administration needs to know what you're doing when you're in terms of your, setting up a fund so that the parents and the community can donate to a school-related effort to raise money for a good cause. And make sure that you keep very, very good detailed records. And as number 4 says, never ever commingle those funds that you've raised for the good cause and deposit them in your personal, say, checking account or savings account. Again, the defense that, well, I'm gonna, I withdrew those funds, on Monday or a week later, so no harm, no foul. That the law does not. This is, again, another one of those areas where the law is very strictly construed, where you're depositing school-related funds into your own personal account. Just by that simple act, all by itself, you've already, violated school policies, you've violated the code of ethics, and, we just have to get on our knees and pray that we're not going to be prosecuted for that, for that one act.
Mike,
Yes.
we do have a question. And I think this is something somebody, if someone has used their personal days for religious reasons, and then they take the day off to go vote, they've used all their personal days. My answer was, shouldn't they have religious reasons as a reason to take leave, so you wouldn't be using your personal days?
Yes. You can request religious leaves as an accommodation.
Okay, so
Yeah.
that would be something they would need to speak with their UniServe director.
Yes, definitely speak with the UniServe director, but there is a notion of, we all, the more common one is accommodations for disabilities, but there are certainly accommodations the law affords for religious accommodations for sincerely held religious beliefs.
Right. Okay.
All right. Very good. I appreciate that question. So we're on remunerative conduct. This is basically the conflict of interest standard. An educator shall maintain integrity when accepting gifts, gratuities, favors, additional compensation. And we'll see in the next slide that it'll contain prohibitions against accepting gratuities and gifts. But there's a big loophole that says you can't do it, but you can if you get approval from the school district. So you can see, like number 2, accepting gifts. I was at a school in Decatur yesterday, and I said, well, does the city of Decatur have a written school board policy that defines the amount, a limit on the gift that you can accept from a parent? And there was a lot of sort of head scratching, and they weren't really sure if they had one. But I threw out, well, some districts have a policy where it's okay to accept $100 from a parent, or maybe even up to $200 from a parent. And then I threw in, I said, well, if you have 10 parents giving you $10 $100 gift certificates, then you'd have $1,000 gifts. And the question was, well, can you do that? And my answer is, well, that depends on the policy and the interpretation of policy. And the way I would argue, yes, you can do that, is the $100 limit is to prevent the appearance of a conflict of interest with that parent's student. And that student only, it doesn't apply to anybody else's student. So it would seem to me permissible to accept $100 gift certificates from more than one parent, because it's the relationship between you and that parent student. And then after my presentation was over, I was talking with the media center media specialist at this school, and she's saying, oh yeah, the PTA is weighing in and making sure that gifts to parents are equitable. And then she said, well, one teacher got $700 in gifts from her parents, but the PE teacher only got like, $25, $30. And that didn't seem fair and equitable. And the PTA is trying to craft a policy that's more equitable so that you don't have such a huge imbalance between, I guess it's a contest that this person is more popular than another teacher, and they're trying to make things more equitable. But that opened my eyes a bit, even to what I was discussing about the $100 gift certificates, where it seems like it was perfectly acceptable at this school for one teacher to get $700 in gifts without violating any policy. So confidential information, again, very broadly phrased, you're to follow and obey all state and federal and state board policies relating to the confidentiality of student records, personnel records, and standardized test materials. Now, to be honest with you, I don't see many violations of sharing confidential information these days. And I'll give you just a quick background to it. This particular standard was radically rewritten after GAE won a case where the PSC wanted to revoke a Gwinnett County educator's license for sharing standardized test questions on a community bulletin board in Gwinnett County. The case was called the Gateway Test. And this educator's point was, we're spending money on meaningless mandated tests, standardized tests that we aren't really teaching the kids. They're not really learning from being forced to take these standardized tests. Well, back in those days, Gwinnett County, and probably no other district, required educators to sign confidentiality agreements. So long story short, we lost our initial hearing and we went to the Superior Court in Fulton County, and the judge said, well, there's nothing in the record to show that these gateway exams were confidential, and this educator had a First Amendment right to express his opinion as a private citizen on a matter of public concern. And we won that, and really, lo and behold, the following meeting, I swear the PSC had come up with this standard to, layer in everything about confidentiality agreements and standardized testing. And I'm not saying that's really a bad idea. Confidentiality is it's a good thing, especially when it comes to student records. But we're also seeing it seems like we're on in a period of time when the emphasis on standardized testing seems to be going down now. The state is requiring fewer of them. And, we're hopefully restoring a little bit more sanity, where we're seeing less emphasis on standardized testing. And really and truly, I can't remember the last time a member had a standardized testing case or anything relating to Standard 7. Standard 8, you're required to report a breach of the code of ethics. And we talked about child abuse. Your duty is to report a violation of the code of ethics of which you have personal knowledge as soon as possible, but no later than 90 days. Now, of which you have personal knowledge. Now, I'm going to be splitting a hair here, but if you hear some gossip, third hand, second hand, fourth hand hearsay information, ideally you don't have personal knowledge. You didn't witness it. You don't have firsthand knowledge of the alleged violation. But I will say this, that if it bothers you and it keeps you awake at night, go ahead and report what you were told about something that happened by another person. And even if you weren't personally a firsthand witness to the incident or the event, there's nothing preventing you from reporting that. Unburdening your conscience and making that report will make you feel better that you have done the right thing and that you're an ethical educator. And never forget, when you're making a report, whether it's a code of ethics or child abuse, what's the first rule that you're going to do when you make a report of such a serious nature? What's the first rule? You're going to, begins with a D, document. You're going to document that you made this report to administration, to the counselor, to the assistant principal, to the principal, to the social worker. You're going to document it and you're going to print that out and you're going to take it home with you, okay? Because you don't know where that written record, that email, could be inadvertently destroyed, or who knows what else could happen to that record. So it's perfectly legitimate and legal to take that copy of that email home with you for safekeeping, because who knows, you might need it. Standard 9, this is another broadly phrased standard. You can read it for yourself. It by itself is really meaningless. To me, in fact, I urge the commission to not put in dignity, because I don't know what preserving the dignity really means. It reminds me of like the Katie Rinderly case, where she was fired for reading a book that was supposedly controversial or divisive. And nobody at her termination hearing, from the superintendent, HR director, on down the line, her principal, could really tell you what controversial meant or what divisive meant. Everybody had their own definition. Well, everybody's going to have their own definition of what dignity of the profession means, for example. So I think it's a very, very vague standard. But we'll see with Standard 9 becomes very important. Lots of questions over Standard 9, because a resignation that would equate to a breach of contract could be unethical. And as everybody watching this knows, that's a hot topic here in Georgia. That's a very hot topic. And what is a breach of contract is in the Code of Ethics, and you would have to go to the PSC website and click on the tab at the top, Ethics, and look at Standard 9 and look at the definitions, and it will tell you what a breach of contract is. And I've actually reprinted it here. It impairs or diminishes a certificate holder's ability to function in his or her employment position, or resigning in a manner that does not meet the guidelines established by the PSC. So resigning often means in a manner that does not meet the guidelines, often means, yeah, we will let you resign or we'll grant you a release only until we find a suitable replacement, for example. And how long is that going to take? It can take a long time to find a suitable replacement And in the meantime, your offer from this other district might expire. But I'm sure, if you're a teacher on this call and you have a contract, you know exactly what I'm talking about. Now, they also have guidelines, like I mentioned, that are on their website that talk about the criteria that the PSC looks at for not finding a violation of the Code of Ethics. And you would have to go to the PSC website and click on ethics, and then click on resources. PSC website, go to ethics, click on the menu, would go to resources, and you will find something called the guidelines for breach of contract. And so by the PSC's definition, if you can resign prior to June 1st without any penalty from the PSC. Now, keep in mind, local districts can look at what the PSC is saying about June 1 and go, we don't care. We're going to have our own deadline by which you have to resign, or we won't let you out of your contract, or we will take liquidated damages from your contract. So standard 9, I'm going to go back. I don't really see a whole lot in terms of educators violated the dignity of the profession. See a lot of situations, whether they're actual PSC cases or just all the calls that come in of how to handle a resignation from a contract or obtaining a release from a contract. It's one of the hottest topics that I know of in education law in Georgia. And we're going to continue to fight that every chance we get. So the last standard, standard 10, you can see it's very simple, but when they proposed this rule, maybe 10 years ago, they proposed a rule that was 11 pages long, and they were going to make 11 pages standard 10 about standardized testing. And after everybody, made a big deal over that, that's not going to go over too well, they reduced it to this one sentence. You're supposed to require to administer state mandated assessments fairly and ethically, and then they keep it real simple to the point of when unethical conduct includes committing any act that breaches test security, and we'll talk about that in a second, or compromises the integrity of the assessment. So this is a short list of testing, do the things that you can do with your class to get ready for the mandated test. And these are all the things that I'm sure you're doing already to get the class ready to take a standardized test. You practice test taking skills, acquaint them with the format, those types of things, encouraging the study, work on listening and reading and following direction skills. All of those are necessary to do well on a standardized test. Now, the brief list on what we can't do in terms of standardized test is teaching the test or coaching students on items or content known to be on the test. Obviously, you can't copy or distribute the test. And here again, it's kind of like standard 7 deals an awful lot with standardized testing. Standard 10 does as well. But I can't remember the last time I've seen a case come up where somebody has copied the test or has taken a look at the test and started to teach items that were actually on the test. And one of the reasons for that is school systems have gotten a lot better at tightening standardized testing protocols. When it was brand new, it was actually kind of messy and kind of chaotic. And in some situations, the standardized tests were in the shrink wrap, bundles, and they would be handed out like a week or 10 days before the test. Well, you know, that's not going to fly. Somebody's going to be curious about what's on the test, take a peek, and, you know, start teaching that stuff. And educators, in all fairness, are caught between a rock and a hard place in that they were being forcefully reminded that if you don't increase the scores on standardized tests, you will be fired. So that pressure led to just, you know, just all kinds of, you know, mistakes and poor judgment because people were afraid of losing their livelihoods. And maybe that doesn't excuse it, but at the same time, there was sort of a mania surrounding standardized testing here in Georgia and probably elsewhere, beginning in the early 2000s and probably that first decade or so. But it seems to have leveled off quite a bit. And as I say, I don't really see these cases come up really ever. I can't remember the last time that I've seen one. So here's just a brief outline of what happens when a complaint goes to the PSC. They first have to vote on whether or not to investigate, and say that somebody filed a complaint against me. I'm not even told that a complaint has been made against me. The only time I'm told that a complaint has been made is if they vote to investigate, that they find some reason or probable cause that Mike has violated the code of ethics, whatever that might be. I then get pretty much a standardized form letter saying, "Dear Mike, we received a complaint that you had an inappropriate relationship with one of your students, and you are to contact Jane Smith, investigator, by Friday," or something like that. And that sends a sense of panic in the educator. What GAE members know not to do is don't call the investigator once you get that scary letter saying that you're under investigation and that you must call the investigator by this date. Don't do that. Call GAE. You can call your UNISERV director, or you can contact GAE directly, and we will open a case and let our network attorney do that talking for you. Let us take that worry and that burden off of you, and let us get involved and represent you throughout the investigation process. After there's an investigation, the PSC will vote again on whether or not to recommend a sanction. If they do recommend a sanction, they will offer the educator a right to appeal or enter into a consent order to, you know, that will finish the case if you sign a consent order, or you can appeal it to an ALJ hearing, ALJ, administrative law judge hearing. And that's where you will find more fairness and due process than you will before a locally elected Board of Education is your ALJ hearings. They are more objective, more dispassionate, and it's just a fairer hearing process at that level. After that, after the ALJ, if we lose, we can go to Superior Court, where your job is located. And if we're unsatisfied there, like I said at the very beginning of the presentation, we have no caps on predetermined caps on what we expend in defense of a member. So if we lose the ALJ hearing, we lose Superior Court, we think we've got a good case to set some precedent, we can go to the Georgia Court of Appeals or the Georgia Supreme Court if necessary. Then the member pays no additional dues or anything comes out of their pocket for that. So with that, I will find my way to stop sharing. And thank you for your time. And is there any
Okay, so I'm going to thank everyone for being here with us this evening. Thank you, Mike. That was very helpful. And thank you for putting it not in lawyer words, but in teacher words we can understand. That really helped, I hope. So Thank you all for attending. We will have another Rights at Night next month. They are on the fourth Thursday of each month. And look for that information in your e-news. And everybody have a great evening.
Thank you, everybody.
See you.